Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox.
Megan Fox.
Megan Fox, a national journalist.
Mastodon. I will never be able to say that.
It feels like the Flintstones live there.
It does.
Well, don't trust women. I think you just touched on that with your last. That's what they brought. We're going to have to bring back chaperones.
Jesus, no.
Just careful, Carol. Stop! Right. Ooh. Hard right.
How did you screw up a stove, Megan? You're a woman. I thought that was baked into you, like at the genetic level, how to operate kitchen equipment.
And honestly, Megan, if you don't like it, I'm sorry. I've been very nice to you.
Think of Dino hanging out outside chewing on a large bone. I highly recommend being targeted by the New York Times and Rolling Stone for weight loss. And I'd say, keep it coming. I need to lose 20 more. Please, keep it coming.
Explain to me, Megan, why did this country not have a holiday once a year? That's the time you vote. If you don't show up and vote, up your ass. You don't get another chance. You don't get, I don't care if you're in the hospital. Crawl to the stake, crawl there. But that's it, 1 day, 12 hours, and then you're done. And you count them that day, and that night you know who the hell won.
I will eat you alive. You want to tangle? You want to go?
The only thing going through my head is, what are you going to do when Megan Fox runs wild on you, brother?
He made a deal with the devil. She's the devil.
He wants that.
Oh, God. Gross! Oh! All right. Penalty box for Slug. Yep. Are you ready to behave yourself now, Slug?
This frustrating rep.
Are you ready to behave yourself? Repossessed puppies? I'm hiding Pork Chop! ASAP! Have you seen his little Pork Chop? Oh my God, Pork Chop is the cutest.
That sounds bad.
Have you seen it?
Pork. It's pork.
Though you may be tempted, do not contact any person or persons mentioned on this stream. Do not even think about contacting anyone who may be the topic of the daily news. If you should do that, the host will question your IQ, possibly call you names, and mock you for disobeying these basic rules of decency.
All the best.
All the best! Hello, everyone. Welcome back to the show. It's me and Rosalyn Duke. We are here in San Francisco live. And we've got our shoulders out, so you know it's serious.
It's serious. It's double shoulders.
Double shoulders.
Quadruple shoulders, really.
Yep. There are 4 shoulders on this stream. I don't know. It could get dicey. It's very risque here. Double shoulders. Where is Brad? Brad is working. He's a working man. He has an invite if he wants to come. If we hear a knock on the door, that's Brad. So we will invite him in. All right, we have documents to go over. We have new, what do we have, Rosalyn?
We've got the expedited, can you add it to the stage?
I can.
There you go.
All right, so what do you call this?
This is the expedited request for reconsideration of motion, lost it, to continue.
All right. So she wants to, basically, it is a motion to stay home, correct?
Correct.
Motion to stay home. All right. So now I know why I don't like this screen share. It's not big enough. How do we make it bigger?
I don't know.
You know what? Share the screen instead, because then we can zoom in.
Okay. Stand by, please.
Stand by, please. Don't worry. We have things to entertain you while we stand by.
It's Douche Canoe and Pregnancy Faker.
Yep. Yep. Steven called me a dumbass. Guys, I do want to give you a warning too, while we're figuring this out. I want to give you a warning about the content of this motion that we're going to read. It is disturbing, to say the least. It is not pleasant. Okay. It's going to have medical stuff involved that is unpleasant. Laura is making some allegations about what's going on with her medically and psychologically that could be very upsetting to someone. So I'm giving you a trigger warning now for self-harm. Also, if you have a weak stomach, it could be upsetting.
Yes. You should have it.
Okay, there it is.
And this one got out of the way. That's super annoying.
Oh, I have to remove that one first. Okay. All right, that's better. That's better.
Zoom, zoom.
Zoom, zoom. And we have fake Laura Owens with us. Thanks for the 5. Says, who'd have thought a diet of burritos and butt stuff would lead to GI problems? Oh, God. Fallen Hero 45, if she even has them. I mean, guys, this is a woman who has fabricated medical records.
Yes.
And faked cancer. So yes. I can't take anything she says seriously. Nothing. Fallen Hero 4567, thanks for the $3 super sticker. And as a reminder, folks, super tips will not work. I mean, they will work. They'll go through. But I won't be able to play them because I don't have OBS in my mobile studio. So send super chats, or you can send Cash Apps or Venmos, which if you do send Cash Apps or Venmos, we are going to spend it directly. That's going to go to fund a House of Prime Rib dinner. We found out we can get reservations late at night, it seems, but we can get them. So if let me put the banner up. If you want to send us to the House of Prime Rib, here are the places you can do that. Right there, scrolling across the bottom of the screen. What?
Did I quit sharing?
No, I still see it.
You do? Okay.
Yeah.
Good.
There are 641 of you here. Please make sure that you hit the like and subscribe. And don't be a stranger around here. Make sure you share it out. Share make sure everybody knows. If you're in the Discord, share it in the Discords. You know, I'm a Discord like lame-o. I don't know how to do it. I don't know how to do Discord, so I don't know how to tell people. In fact, you'll have to apologize to Locals for me, because also on my laptop, I'm not logged into Locals. So I basically have to go to my phone, go to Locals, and post something like, hey, I'm live, go find the link. I mean, I guess I could do it from my phone, but I mean, we have things to get to. All right, Rosalyn, let's take turns reading these pages. How about you start?
Okay, introduction. Petitioner Laura Owens respectfully requests reconsideration of the court's prior denial of her motion to continue the Domestic Violence Restraining Order, DVRO, renewal hearing presently set for October 21st through 22nd, 2025. New objective medical evidence demonstrates that proceedings as scheduled would pose life-threatening medical risk to petitioner and deny her the ability to meaningfully participate in these proceedings.
Seems legit. Totally legit. Oh,
You-
wait, they're saying they can't hear you,
Uh-oh.
but they can hear me fine. Let me put the microphone closer to
Is
you,
that better?
because I project like crazy.
Is that better, chat? Can you hear me now?
There's a bad echo? There shouldn't be.
Ruh-roh. I don't even have I'm muted, aren't I?
Are you muted?
Yeah.
Star says she can hear us.
Oh.
I have the mic jacked up all the way. Hold on. Let me do something else. Hold on. I know what I can do. Instead of automatically adjust mic, let's just, all right, now try, Rosalyn.
Is this better, chat? Can you hear me now? Can you hear me now?
Okay.
Okay.
I think we're good. It's good enough. They say keep going. Yeah,
Okay.
guys, we are going to have, I encourage you to put your headphones in. It will make it much easier. No, Rosalyn is actually closer to the microphone than I am.
Right.
So it's just that she's,
You've got the wall behind you
Yeah.
bouncing it back.
yeah, just try to project a little
Okay.
more.
I'll yell at you.
There you go.
Okay, new medical evidence.
All right. Attached as Exhibit A is a letter dated October 17th, 2025, from Dr. Colleen Green, a medical provider and petitioner. That petitioner has been seeing since September of 2024. Dr. Green states that participating in a hearing next week would be life-threatening for her. Life-threatening, Rosalyn. Because of the combined psychiatric and physical decline. This new evidence, unavailable when the court previously ruled, that's convenient.
Right.
That it wasn't available when the court ruled on this last week.
Brand new.
Just found out how deathly ill. Directly rebuts any assumption that petitioner is capable of safely participating in a contested proceeding at this time.
Uh-oh, lost my mouse. Hang on.
In addition,
Uh-oh.
what just happened? It jumped.
It's being silly. Hang on a second.
Sorry. Okay. In addition, petitioner's other treating medical providers have diagnosed extreme anorexia after a 50-pound weight loss to 84.9 pounds, and she has had gastrointestinal bleeding. Okay, listen. We have also had, we've known about this extreme weight loss since the trial.
Right.
What has she done?
Since June of 2024.
2024. What has been done to treat the anorexia, which everyone knew she had back then till now? You're just now figuring out that you have this?
Right.
Come on, Laura. This is just ridiculous. I mean, I agree she needs medical attention, but she should have been hospitalized last year.
Right. Right. And what we saw in January, I mean, it's pretty shocking.
She does look thinner to me now than she even did
in January. She looks thinner. So I don't know what
Oh,
she
in
looks like
January.
right
We
now.
don't know what she looks like now. That's true. That's true. Yeah, what you guys are hearing is just an echoey room. It's just because we're in an open space. So it's the best it's going to be. All right. Her most recent laboratory results should absolutely be questioned and verified.
Exactly.
Lab results from Honor Health Medical Group Lab, Thompson Peak, collected August 7th, 2025, shows hemoglobin and wait a minute, August 7th? Isn't it October?
It's not new evidence then.
This is not new evidence.
What?
August 7th, so you knew about this since August? And hematocrit, I don't know what that is. Hematocrit levels approaching transfusion range since August, Rosalyn.
And she's still not seeking medical attention?
Apparently not. Apparently not. Approaching transfusion range, corroborating the seriousness of her condition. Well, why was it so serious? And if it was that serious in August, why wasn't she hospitalized then?
This is wild.
Okay. Following multiple episodes of vomiting blood, again, doesn't go to the ER. You're vomiting. Chat, let me ask you a question, chat. I'm sorry, chat. You know what? Hold on. We need a poll for this. We need a poll because I really need to know. You vomit blood. Here are your options. Go to the ER. Immediately. 2. Do nothing. No, I'm sorry. Wait, this is going to be. Go to the ER. Let's see. Just call the doctor.
Right.
Okay. Adding an option. Here's the third option. Wait until you have a court date you need to get out of. You don't want to go to. Wait till you have court. There we go. Start poll.
Wow.
All right, folks.
Wow.
What do you do in this situation? You are vomiting blood. What is the correct answer, chat? So far, we have 100% go to the ER immediately. All right, 61% go to the ER immediately. Who says call the doctor? 5% says call the doctor. We have an entire 32% of you who would wait till you have court.
Well, it has time to go to the doctor.
And you could need a good excuse to get out of court. Traffic court, whatever it is. Oh my goodness. Yeah, you don't wait 2 months. I mean, this seems insane. All right, what's the next thing here?
Following.
Following multiple episodes of vomiting blood, petitioners treating physicians advised that urgent gastrointestinal testing and specialist evaluation were medically necessary. Urgent.
In August.
No, wait, I don't think this part. Was this part in August, or is this she's saying happened now?
Oh, so
since
now
she had the tests in August.
she's suddenly vomiting blood now.
Mm-hmm.
Okay. Wouldn't they have treated her with something, proactively in August?
I would think so. I don't know what hematocrit is. I don't care
I'm
that
not a
much.
medicalologist.
I'm not a doctorologist, as Mo would say. Let's see. So petitioner was referred for gastroenterology consultation scheduled conveniently for October 22nd, the second day of her trial, which was the earliest available date for the required procedures. Okay, I don't believe this because it couldn't be. If she were, how could it be? Wouldn't she have known this last week? How long has she been trying to get? And I don't believe her that she could get a specialist appointment within a couple days. That doesn't happen.
No. I mean, you could see somebody in an emergency situation in the hospital.
If you go to the ER.
Yeah.
Because guess what? When you're in the ER, there are gastroenterologists on call.
Right. Exactly.
But if you're trying to get into a specialist's office, these days the wait is 6 months, sometimes more. I had some special neurology specialist I had to take my kid to. We can't get in till May. I just made the appointment. I couldn't get in till May. I don't believe that she could just make a call. Even from August to get to October, that's still a short period of time.
Yeah.
If she made the call in August, but she didn't because she would have known. She would have been able to say this to the court.
She would have known ahead of time.
Yeah.
I think we've been through this before with some other case. Sounds familiar.
Mm-hmm.
Wow.
Yes, it is happening in the Hales case too. The overlap with the hearing date is entirely unavoidable. I like that it's bolded in case the judge can't understand the emphasis.
Right.
Entirely unavoidable as the appointment was made immediately upon referral for a very serious condition. Notice that she does not tell you what was the referral date.
Right.
What is the referral date? There isn't a referral date here. It doesn't say I went to such and such doctor on this date and they referred me on that date.
Right.
Okay. Postponing this appointment could delay essential diagnostics for several weeks and significantly increase the risk of further bleeding, worsening anemia, and medical destabilization. All right, so here's the procedural urgency and request to rule on the papers. I believe it is Rosalyn's turn.
Hey, today is October 17th. So that was Friday?
Yes.
And the hearing is scheduled for October 21st to the 22nd, 2025. The intervening weekend, October 18th through 19th, leaves no business days to notice or calendar an ex parte application. Accordingly, there is no practical opportunity for a hearing or oral argument before the scheduled dates. Given the medical urgency and the newly submitted documentation, petitioner respectfully requests that the court rule upon this request on the papers pursuant to its authority under California Rule of Court, Rule 3.1308A1, and San Francisco Superior Court Local Rule 8.7. These provisions authorize the court to determine matters without an oral argument when good cause and exceptional circumstances exist, both of which are present here. As proceedings next week would place petitioner at a documented life-threatening medical risk. Good faith basis. This request is made in good faith and not for the purposes of delay. Petitioner seeks only sufficient time to stabilize medically and safely participate once her treating professionals determine that doing so will not pose a life-threatening risk. Prayer for relief. Petitioner respectfully requests that the court vacate its prior order.
Yeah, that's going to happen. That's going to happen for sure. No, it isn't.
Prior order denying continuance. Grant a reasonable continuance of the DVRO renewal hearing to allow for medical stabilization.
That might happen, but I don't see the court vacating its prior order.
Right.
No.
Order any further relief the court deems just and proper. And it looks like the last page is her signature.
Okay.
So let's the next document.
Yes, let's pull up the next one. So this will be her declaration.
Let's see. Don't want to share my whole computer with you guys. I love you guys, but
Well, here, we'll just take it off the screen for now while you get the next one set up. All right, while you're doing that, I'll pull up some of the super chats and comments from the chat because some of you guys have some good things to say. E. Poindexter, thanks for the 10. Scandalous, risque, shocking. Oh, I mean, the trial, not the shoulders, but those are worth my Starbucks money today. Thank you, E. Poindexter. Fake Laura Owens, thanks for the 5. If you want to make it bigger, on it. That's what Mama taught us. And Fake Laura Owens, thanks for the 2. Loosen your top, then we can hear you better.
exactly.
And hey, it's me. Thanks for the 5. Will there be a Legal Vices tribute stream? Your intro made me miss his laugh. You know, we did one. We did several. Maybe you missed it, but we did a trucking stream.
Yeah.
Flux and me and Connor and other people were there. I don't remember. We did other ones too.
Yeah.
Nick Starro did one.
Mm-hmm.
We did a lot. We did several of them.
I did that video.
We did the fundraiser, and then there was a video. There were a lot. Maybe you missed it, but there were a lot at the time. Just Jay Hip, thanks for the 5. I believe her. This sounds serious. Prayers. I do believe her medical condition is serious.
I believe it's very serious.
But she's not taking care of it up until now.
Yeah.
So why did the next 3 days matter?
Yeah, and why? I mean, why right now?
Why right now? Because she has court.
Well, I know.
But
she knew she had court a month ago.
True. Dawn Hazlitt, thanks for the 5. Yet she traveled to California several times in September. Yes, she did.
She did.
Mm-hmm. So there was no problem traveling for vacations just a month ago. Interesting. Kelly Rager says, if there is internal bleeding at all, the doctor would have done immediate investigation into why and as much as transfusions. Yes, I think that's common knowledge that would be a serious and immediate situation.
Mm-hmm.
Elfie says any ER visit at any time would expedite treatment. She could have gone to the ER on Friday and been ready for court on Monday. Yes, she could have been. Also, keep in mind that Arizona is a very short plane ride from there to here. It is very short. It is not
like 45 minutes.
Yeah, it's a 45-minute, maybe an hour. Like, it's not a long trip. Kahoma says hematocrit is a measure of red blood cells in the total volume of blood. I didn't know that's what it was called, but thank you for that. Are there nurses in the chat? I bet we have a lot of nurses and medical professionals in the chat. I would love to hear from you guys on what you think about this. Yes, so right. Did Lauren stream about this earlier? We were out on the town shopping and picking up things we forgot. But yes, it's true. She's not a medical doctor. Apparently the doctor involved in this is a nurse practitioner, psychiatric. She's also
double?
Yeah, okay. She's also 130 miles away from Laura's home.
Yeah.
And she appears online to require in-person visits. So do we believe that Laura traveled 130 miles away from home when she doesn't drive
right
to see this person? Does anyone believe this? Anyone? I know just Jay Hip does.
Just Jay.
Yeah, just Jay. I'm looking at your comments to make sure I don't miss anything because I backed up. Oh no, Bruce says she's puking up the twins. That's a lot of No, Bruce. Chance NP says there are doctors in California. In fact, probably her family doctors in San Francisco,
Probably.
right here where she grew up. She probably has
Yeah.
very good doctors right here. Jay Daniels says this is just a preview of what will happen with her criminal court. Yeah. Crazy about Mercury says, Megan, what on earth are you doing? Both of you are showing bare shoulders. We are living on the edge.
We are.
We're living on the edge. I know it's very shocking stuff here.
Yeah.
We're considering opening a page on only shoulders.
Only shoulders. Yes. That would be great. Next will be only ankles.
Only ankles.
No feet, just ankles.
No feet. That's a bridge too far. Bridge too far.
Absolutely.
Okay, let's see. Oh my goodness. I'm just looking at I'm behind on your chats now because I was reading supers and now I've missed a bunch of things and I really hate when I do that.
It's so hard
You
without
guys-
the setup.
I know. You guys have such good things to say. Heard that she was the one. Oh, Just Jen says, we heard she was the one who diagnosed Laura's autism. Oh, that's interesting. Maybe. We don't know. I don't have that information.
Does that date coordinate with the diagnosis?
I don't know if we ever got any information on that diagnosis.
Huh.
Did we? She would have to get permission to travel, Linda, and she has not, to our knowledge, asked the
Even
prosecutor for so she has no intention of being here. But I made the decision last week, even when I knew that she was not going to be here, that we would be here because court's going to happen tomorrow. It's going, well, unless, I mean, there's a possibility that the
There's potential.
judge could rule on this
Today. Yeah.
and cancel tomorrow. And I guess it's possible that she could be granted a continuance, but I don't know. Badass bitch says, I'll pay to see those shoulders again. Fantastic.
Well, thanks.
You guys are killing me. God, the chat is flying. There are 943 of you here. Make sure you hit that like button. And please make sure that you share the stream. Jay Daniel says, nurse here, this is not an expected course of treatment. Interesting.
An expected course of treatment? What would be expected?
What would the expected course of treatment? I would think immediate hospitalization.
An endoscopy at least?
Something, but immediately under a doctor's care.
Yeah.
To be younger, thanks for the 2, said Lauren, said the doctor is not a medical. Yep, that's right. Marissa F, thanks for the 5. Cover your shoulders. My husband is on this app. For those of you who are just Laura Owens fans and you have not been paying attention to the what the hell's thing, this shoulders joke is going over your head.
Yeah.
But there is a channel out there that likes to criticize everything we do. And in one particular thing they went off half-cocked crazy about the other night was that we keep on showing our shoulders.
Yes, in an attempt to become more attractive.
To be more attractive and get more super chats.
Oh, is that what it is?
Yes. And that my cleavage is specifically designed. And that I keep showing cleavage for more super chats too, apparently.
Oh.
I don't have any of that today. There's no cleavage today. Just a fun necklace. Oh no, housekeeping is vacuuming.
Housekeeping?
Can we tell them to stop vacuuming?
Can you guys hear it? Is the question.
Can you now hear the vacuuming going on? Because now there's vacuuming. All right, let's hit some more of these questions. Some of you have more questions. E. Poindexter, thanks for the 2, says she's claiming medical grounds. Browns. Marissa, we got Marissa's. Chance NP, thanks to the 10, could be seen serious or could be concerning, but not immediately dangerous to life. Would need to see the labs. May need endoscopy or some protonics and bland diet.
Yeah.
Okay.
Yep.
Tribal girl, thanks for the 5. It worked. I don't know what worked, but
yay!
Wait, what do you mean it worked? Did the court rule or something and we don't know? Hold on, let me check my text messages.
Wow.
I'm not seeing anything, but let me check in with with who would know.
Let's see. I don't have 87 missed text messages.
I don't either, and I would think that I would.
Yeah.
I would think that I would have it. Starcasm, good to see you. Star, thank you so much, by the way, for the House of Prime rib money.
Yes.
We are definitely, we don't have enough for a dinner yet, but we now have enough to go to the bar and maybe have a drink and an
cocktail. Yeah.
We can have a cocktail, maybe an appetizer, get some pictures. Starcasm, thanks for the 10. Lies, lies, and more lies.
Yes.
All right, let's see. Oh, the shoulders worked. The shoulders worked to get more super chats. That's what it was. Okay. You guys scared me for a minute, and I thought maybe the court had ruled on something, and I missed it. All right. All right, let's bring up the declaration now.
I've got it up.
All right, here we go.
That's what she said.
That's what she said. Okay. You want to start?
Oh, sure. Declaration of Laura Owens in support of expedited request for reconsideration of motion to continue. Wait. This is the other one. Yeah. This is the declaration. Gotcha. Okay.
I know it's very similar, okay? This is going to be very similar, but it has a little bit different of her like testimony of what she's saying happened.
Right.
That's what a declaration is.
Sure. Laura Owens, Laura Owens, I'm not, well, anyway, declare as follows. I am the petitioner in this matter. The DVRO renewal hearing is currently set for October 21st through 22nd, 2025 in Department 405A. Since the court's prior denial of my motion to continue, I have obtained new medical evidence. Attached as Exhibit A is a letter dated October 17th.
Did we get the exhibit? I never saw the exhibit. Is it at the bottom of this?
I don't think so. This is only 3 pages.
Oh, shoot.
Attached is Exhibit A letter dated October 17th, 2025 from Dr. Colleen Green, a medical provider I have been seeing since September of 2024. Dr. Green states that that participating in a hearing next week would be life-threatening for her because of the combined psychiatric and physical decline. This new evidence, unavailable when
the court previously ruled directly, rebuts any assumption that I am capable of safely participating in a contested proceeding at this time. In addition to Dr. Green's findings, my other treating medical providers have diagnosed extreme anorexia following a 50-pound weight loss, accompanied by gastrointestinal bleeding. Following multiple episodes of vomiting blood, my treating physician advised that urgent gastrointestinal testing and specialist evaluation were medically necessary. I was referred. This is exactly the same?
It seems exactly the same.
Is there more? Wait, what? Scroll down to number 5.
No, it's the same.
It's the same. Why did she submit 2 of the exact same documents?
The other one had more pages.
It did. All right, so this is no different.
I don't think it's any different. Let's see. Yeah, no, that so far all the way through 6 is the same. Let's go down to 3. Declare under penalty of perjury.
Well, now. I don't. What do we think about that?
It's douche canoe and pregnancy faker.
Yep.
Yep. I'm missing my Laura Owens buttons right now.
Yeah.
What?
Right. It's always thought it was 7 a.m.
Look, I just have one thing to say about all of this.
Bitch, what the fuck? Bitch, what the fuck? Bitch, what the fuck? Bitch, what the fuck? What the fuck? What the fuck?
We just scan through it. We're deciding whether or not we should read the motion in limine, but has it been redacted? Did you redact that?
Yeah, well, it's only the only thing to redact is the top.
The top, okay. It is 30 some pages. Should we start the motion in limine, guys? Do you want us to start reading that? This is who she wants to have kept out of the trial, which is pretty much everyone, I think. Everyone.
You, me, the dog next door, the horses.
All right. We'll see how much of this we can get through. when we have to go, we have to go. I have a stream at 4 with Tug for What the Hails, so I have to go for that. But we'll start. Plus, we have to get something to eat in between. Yeah. So we have until
snacks. I need snacks.
Yeah, we need snacks. We're gonna need something. We should order in. Is what we should do. We should Uber in, or not Uber in. What is the
Uber Eats?
Uber Eats. We should
go to the vending machine.
We're not going to the vending machine. But tonight's the night to order in, though, because we have too much to do.
Yeah.
Okay. Yamaha biker. Let me get my hip waders on. The shit's about to get deep. Yeah.
Possibly.
Possibly. Yeah, we definitely. Yeah, DoorDash. We can DoorDash it.
DoorDash it.
I have a DoorDash app on here. What should we order? Should we let the chat tell us what to get?
Yeah, chat. What are we hungry for?
What are we hungry for, chat?
What's good around here?
Yeah, I don't know what's good. There's a taco place not too far from here that looks really good. Maybe they would DoorDash it.
Maybe we could have a burrito.
We could have burritos. No, there's no room service. We're in a discount hotel.
Oh yeah, no, we're way too cheap for that.
There are free waffle makers though in the morning. Yes. So that's good news. Street vending machine. The chat is going for vending machine. What? Is there good Chinese food here? I bet there is.
I bet there is.
Maybe we should do Chinese.
Yeah, or Thai.
Or Thai. Thai. Let's do Thai. I'm in. Okay. All right. We'll DoorDash some Thai. All right. We'll have to do that in a minute because we're going to be on a tight schedule here.
Yeah, you are. You're getting it pretty tight to join Tug.
I know, but we can do it. We can do it. All right.
It's not like you're ever on time anyway.
That's always true. I'm never on time. So I'll tell you what we'll do. We will go until, because it's 2:50, we'll go until 3:15.
Okay.
And then we'll cut it off at 3:15, whenever that is. Then we can come back and do this later.
Or we can do mukbang for super
We can do mukbang for super chats. Should we just DoorDash in now and just eat for super chats?
No,
that's gross. I can't do that. I can't do that. It would just be gross. All right. Identification and stated purpose of testimony. These are to exclude witnesses. Mr. Woodnick is thus offered not as a percipient, that's a big word, a percipient witness, but as an expert to give personal opinions about petitioner's credibility and mental state, topics that are inadmissible under the law. Lack of personal knowledge and relevance. Mr. Woodnick has no personal knowledge of petitioner's relationship with respondent Maricini. I feel like she's guessing at that.
I think
His only involvement with petitioner arose while he represented other clients in what? In what? Oh, there we go. You can start then.
In Arizona. Those unrelated proceedings, excuse me.
Unrelated? Oh, no. What?
Oh, my goodness. Okay.
Oh, this is a good observation, chat. Miku says, this is pure chat GPT, M dashes and lines and all. You're right. You're right. I don't know. Chat GPT makes it so easy to see when if you don't change it, like how it formats things. I'm surprised there's no emojis, like a little hammer of justice emoji.
Yes, exactly.
Oh my God. Funny.
Okay. Whoa. Have no bearing on whether petitioner continues to harbor a reasonable apprehension of future abuse from respondent as required by Family Code 6345A. Testimony lacking firsthand knowledge is inadmissible, Evidence Code 702, and irrelevant, 350. Okay.
I think I found our restaurant.
Okay.
It's called House of Thai.
Seems to be a theme around here.
I think we need to go with House of Thai. I don't know. It's a sign.
House of this, house of that.
House of that. Is everything here called House of something? We're getting
House of what it is.
We're getting a House of Thai. What do you like? Do you like pad Thai, pad kimao?
I like pad Thai. I also like the green curry.
Ooh, green curry. Well, which one would you rather have?
I think green curry.
All right. How about if we do a pad kimao and a green curry?
Sounds good.
Do you like chicken or tofu or
chicken?
chicken.
No, not tofu. That's weird.
I love tofu and Thai,
Oof.
but it's because they fry it. You know, the fried kind, not like
Yeah.
the smushy kind.
No.
But no, we'll do chicken.
Okay.
And then we'll share. How's that?
Great.
Okay, chicken. And how's your spicy level? We're learning about Rosalyn today. Medium spice, mild spice.
Mild spice.
Okay.
Well, you have to stay with me, so let's do mild. Mild spice.
I'll get extra hot sauce on the side.
There you
How
go.
about that?
Perfect.
All right. We don't need extra that. We'll do extra that. Sorry, I'm ordering. You keep reading. I'll
Okay.
order quietly.
Section C, bias, hostility, and retaliatory motive. The record establishes an extraordinary conflict of interest. According to the court-generated email chain dated August 1st, 2022, Exhibit 4, petitioner reported to the Maricopa County Superior Court that she had been assaulted and had strong reasons to believe that both the defendant and his counsel were involved, and that there was a pending FBI investigation. Dun, dun, dun. The court's judicial assistant forwarded that message to Mr. Woodnick and reminded petitioner that ex parte communications was not permitted. From that moment, Mr. Woodnick became aware that petitioner had personally accused him of serious misconduct. You mean she lied?
Do you think it says here their green curry is spicy?
Really?
It does.
Like extra spicy?
Well,
Coconut curry?
it says with bamboo shoots, string beans, carrots, bell peppers, and basils in spicy green curry.
Okay, no, it's probably fine.
You think it's fine?
Yeah.
All right. So why does everything come? What? Yeah, we want it with rice.
Rice, baby.
You guys you're watching someone who's medium smart try to order things, and it's really difficult. Why am I having trouble with this? Your recommended options. I don't know. We're just gonna get whatever we get, I guess. Oh, medium is the lowest we can go.
Right.
I just figured
Okay.
it out.
There we go. Good.
All right.
Since that disclosure, his actions toward petitioner have reflected sustained hostility. Bullet points. I hate bullet points. He has described petitioner publicly as someone who fabricates abuse allegations and suffers from unreasonable fear. Okay.
Who is this? Who is she talking about?
Woodnick.
He suffers from
No,
unreasonable.
he's saying that he has said that about her.
That she suffers from unreasonable fear?
She fabricates fabricates abuse allegations and
Okay.
suffers from unreasonable fear.
Well, she does.
Yeah. Well, we've seen that.
Do you want Thai iced tea?
No.
Or do you want to stick with water?
Water.
Okay.
On March 7th, 2024, while representing a different adverse party. I mean, like she's done this before.
Good Lord.
He issued a Woodnick Law PLLC press release repeating those phrases and asserting that petitioner had falsified evidence, statements made months before any evidentiary hearing or ruling in the Arizona matter. Petitioner later filed a State Bar of Arizona complaint file number 240263, documenting that press activity and other unprofessional conduct, although the bar closed the file. Without formal discipline. The existence of that complaint demonstrates that Mr. Woodnick's professional conduct was formally challenged by this petitioner.
Okay, so what does that have to do with anything?
And
you also called the FBI on him. Yeah, keep reading. I'm still making this happen.
having been personally accused of abuse and professionally reported for misconduct, Mr. Woodnick. Wow, we're going to continue with the accusations, huh?
Oh no, really? What does it say?
Having been personally accused of abuse and professionally reported for misconduct.
Oh my God.
Oh,
Has
Zaddy
he read-
Woodnick.
Oh my. Laura, stop doing this.
This sounds like somebody else, though, too.
Mm-hmm. Having been personally accused of abuse.
And professionally reported.
It should say having been falsely accused of
Right.
abuse.
Exactly. Mr. Woodnick now seeks to testify as an expert that petitioner fabricates abuse allegations. That sequence creates a textbook retaliatory motive under Evidence Code 780F, a desire to vindicate himself by discrediting the complainant. Why does that sound weird to me? Complainant. Anyway. See People versus Allen, 1978, 77 Cal App 3D 924931. Wow. Okay. Bias and hostility go directly to credibility.
Food ordered.
Woohoo! Such bias renders him incapable of neutrality. Under Family Code 217B, the court may exclude testimony that would cause harassment or intimidation of a protected party. And under Evidence Code 352, it may exclude evidence whose probative value is outweighed by the danger of undue prejudice. Mr. Woodnick's participation meets both standards. Does it? Does it though?
Does it though?
Does it?
I'm not sure about that. All right. Improper expert and character testimony. Mr. Woodnick's proposed opinions that petitioner fabricates abuse allegations or acts from unreasonable fear. Hey, Roz, when you're in Streamyard, can you star chats? Are you allowed to do that in mine?
Mm-mm.
You can't do
I
that?
can't.
All right, just wondering.
I don't even think I could comment in yours.
Unreasonable fear, concern, credibility, and emotional state. Not any field of technical expertise. Such opinions are barred by evidence code and constitute impermissible character evidence. See People versus whatever. Expert may not comment on veracity of another witness. Admitting those opinions would usurp the court's role as fact finder. Okay. But is he a character witness? I don't think he's a character witness. He's going to be testifying about the facts as he experienced them,
Right.
I'm assuming.
Right.
Oh, and I bet it's going to be to rebut. I know what he's testifying about. He's the rebuttal witness for David Gingras. David Gingras is supposed to be her witness about the Mike Maricini thing calling 911. And Greg is the one who's going to say, I was in chambers with this man, with the judge, and she said, no. She said she could have her security make everyone safe.
Right.
And he can also testify that Mike was there under a lawful subpoena.
That he issued.
That's what he's there for. He's not a character witness. What is she on about?
She's trying to slander him in a court document.
Mm-hmm. Respondent's disclosure asserts that Mr. Woodnick will corroborate findings in Arizona paternity litigation. Corroborate findings. Okay. This representation is incorrect. The Arizona cases contain no judicial findings that petitioner fabricated abuse allegations. What? Is she kidding? No, it doesn't have. Okay, she's right. There are no findings that she fabricated abuse allegations.
Oh.
But there are findings that she fabricated evidence and committed perjury. Those are the findings.
Yeah.
Like she's just misleading. This is misleading the court. Any claim to the contrary, and I don't think it was claimed contrary, is a misstatement of the record and should be barred as misleading under evidence code. As the Court of Appeals held in Ritchie v. Conrad, a renewal hearing is not a retrial of the original abuse allegations, including foreign unadjudicated introducing foreign unadjudicated narratives would violate that rule and frustrate the purpose of Domestic Violence Prevention Act. Oh yeah, the formatting on this is so ChatGPT.
Mm-hmm.
This is so terrible. Unfair prejudice and confusion. Permitting Mr. Woodnick to testify would transform this renewal hearing into a collateral trial on Arizona disputes, disciplinary filings, and press publications. The minimal probative value of such testimony is far outweighed by the danger of unfair prejudice, confusion of issues, and harassment of the protected party. The court should therefore exercise its discretion to exclude him entirely. Procedural, you want to start with G? You can read G and go down to the next page then.
Procedural improprieties in subpoena issued to Mr. Woodnick. On October 3rd, 2025, Respondents Counsel Omar Raul Serrato issued a purported trial subpoena to Mr. Woodnick commanding his appearance at the San Francisco Superior Court hearing on October 21st, 2025. The subpoena is procedurally defective and unenforceable for multiple reasons. First, the subpoena seeks to compel the attendance of an out-of-state witness residing in Phoenix, Arizona. Well, so?
Wait, who's the, what? She's saying that the subpoena for Woodnick is not, she's arguing that it's,
because he's from Arizona.
what does that have to do with the price of rice in China?
Let alone San Francisco.
Nothing. Jimmy cracked corn and.
California subpoenas have no extraterritorial effect and cannot compel the attendance of a non-resident without compliance with the Uniform Interstate Depositions and Discovery Act Code, civic blah, blah, blah. No such domestication proceedings have been initiated in Arizona, and therefore this subpoena has no legal force outside of California. Second, the form shows no clerk's issuance or court seal, only the handwritten signature of Mr. Serrato. Under code blah, 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 a subpoena for trial testimony must be issued by either the court clerk or by an attorney as an officer of the court, only for witnesses within California's jurisdiction. Because Mr. Woodnick is out of state, Mr. Serrato lacked authority to issue it.
Oh, the whininess. All right.
You can go.
Third, there is no proof of witness fee, tender, or proper service. Civil procedure requires that statutory witness fees and mileage be paid or tendered at the time of service. The subpoena file contains no such proof, nor is there any executed proof. So she's just claiming there's no service. He probably accepted via email service, so there isn't that, you just accept it.
Right.
I guess there is a proof of service that you have to file, but I don't know. I'm sure she's wrong. That's all I can say about that. Fourth, even if procedurally valid, the subpoena seeks testimony that is irrelevant, cumulative, and harassing. Of course. Mr. Woodnick's proposed opinions pertain to unrelated Arizona matters and to petitioner's supposed credibility, topics far outside the narrow statutory limit. Or inquiry, sorry, not limit, inquiry. All right, scroll. Court should quash or disregard any subpoena that would impose undue burden or intimidation on a protected party. Hey, you know what this ChatGPT tells us? Tells us that David Gingras is no longer writing her complaints. He's out. Or he would be writing this stuff for her, as he has done for this entire thing.
Lacking a certain level of snark that would indicate that he had authored it.
There's no Trump derangement syndrome either. I've noticed. I'm missing the Trump derangement syndrome, which does not appear to be here. This is definitely not a David Gingras special.
No.
This is written. She wrote this.
I mean, I can still hear his influence, but it's not his authorship for sure.
Yeah, but I don't think he even helped her with this.
I mean, they've been in their relationship for quite a while now, so maybe she's just learned him off.
Yeah, I mean, I don't think that he helped her with this.
Yeah.
So she's claiming that it's jurisdictionally invalid and substantively improper, requesting that they quash the subpoena. Okay, let's scroll down. All right, the official word is the court has not ruled yet. I believe that Omar is putting in his response.
To this?
Yeah.
Okay.
To the motion to continue or whatever. Good. To the motion to stay home is what I'm calling it.
Motion to stay.
Motion to stay home, Judge.
Yeah.
Motion to stay home and not go to the ER.
Yeah.
Even though I'm dying.
I'm gonna die.
I'm gonna die, but I don't have to go until the 22nd.
She won't die until after court has, been moved. It just.
All right. Section 2 to exclude John Berryhill. This should be good.
Digital forensics expert.
All right, go ahead. You start.
Identification and stated purpose of testimony. Respondent seeks to call a privately retained digital forensics witness, Mr. Berryhill, to introduce a 2024 report and text messages from 2016, 2017, materials never filed in this case. They should have been, and unrelated to the record supporting either the 2018 restraining order or its 2020 renewal. No forensic examination of petitioner's filings has ever been ordered by this court. The proposed testimony is unfounded, irrelevant, and inadmissible. Improper introduction of new exhibits never in the record. Respondent's 2025 executed exhibit list identifies new exhibits from 107. Oh, item 107, sorry. Digital forensics report by John Berryhill dated May 4th, 2024, and items 114 through 118, text messages from 2016 through 2017. These materials were never part of the 2018 evidentiary record that established the restraining order, nor the 2020 renewal record. Introducing them now attempts to reopen and retry matters conclusively determined years ago. Contrary to family code, blah, 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 Ritchie versus Conrad, renewal hearing is not a retrial of the original abuse allegations. Evidence that was never admitted or considered previously or hidden is outside of the permissible scope of this proceedings and must be excluded. See, no such document exists in the 2018 or 2020 record. The court files supporting the 2018 order and 2020 renewal of Owens v. Mercini contains no medical letters, no ultrasound records, and no comparable exhibits, let alone anything falsified or misleading. Neither party nor the court ever referenced or relied upon such material. Mr. Berryhill testimony that petitioner filed falsified medical letters and ultrasound images is therefore baseless. Testimony predicated on documents that never existed in this record is speculative and irrelevant under evidence code, blah, 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 and its only effect would be to mislead and prejudice the trier of fact contrary to evidence code.
All right, no court authorized or neutral forensic review. The court has never ordered any forensic examination. I don't think that matters. If the defendant wants to have one done,
It's newfound
he
evidence.
can do it. And it is newfound evidence. He didn't know he had all of this.
Yeah.
Mr. Berryhill's work was privately commissioned by the respondent's counsel. So what? That's how all experts are commissioned. By what does that mean? She thinks
By divine
the
intervention.
judge has to order it. The judge has to order that it be done.
Right.
Give me a break. That's not how this works. That's not how any of this works. Conducted without notice to the petitioner. It was his laptop and performed outside any judicial supervision. Oh, it has to be supervised, Roz, by a judge.
Like the judge
has to like stand over them and like watch it happen. Come on.
They don't know what's happening either.
That's not how this works.
That's not how any of this
A
works.
privately retained analyst cannot be presented as a neutral forensic review, and admitting his report would mislead the court into believing that an official determination of fabrication exists when it does not. Ma'am, you sent him in the text messages some medical documents, which you said in court in Arizona are not yours, and you did not do that. They are fabricated. You said that. You said they are fabricated. Now you want to make believe that Greg Gillespie had a time machine maybe and like went back and fabricated those and broke into your phone. But you said under oath that those records aren't real. You said those letters are faked, but you didn't fake them. But this forensic report shows that they absolutely came from your phone.
Right.
You have a real problem because you talked about this in the Arizona court under oath. That's the problem here, right, Roz?
That's the thing that connects the two.
Yeah, you made a big mistake. Huge. And that was a big Gingras mistake, if you remember.
And that was before his time.
No, it wasn't before his time. Oh my God. How are we still doing this 2 years later? Are we at 2 years? Year and a half? Year and a half?
Well, we found out in December of 23.
Oh
We're
my,
almost at
2 years. Same with the Hales case. It's
Yeah,
been going on for
They kind of came in at the
2
same time.
years. Oh my God. No wonder it's like I can't cover anything else because these cases take up all my damn time. They just never end. All right. Privately retained, what is that? Testimony lacking neutrality or court authorization fails to satisfy the reliability of fairness standards of Evidence Code 702 and 801 and should be excluded. Absence of method, or why don't you read E? We can switch off on the letters. Let's do that.
All right. Absence of methodology or validation. The Digital Forensics Report, Exhibit 107, identifies no software, extraction method, imaging log, hash value, or validation procedure. It provides no chain of custody documentation. Yes, it does.
Yes, it does.
Yes, it does.
And also, she's wrong. John Berryhill could give them all this information. Maybe it's not in his report, but he can certainly give it to them. The software, the extraction method. And actually, the extraction method was in there.
I thought there was even chain of custody.
I'm sure that was in there. This is just, she's making this up, you guys.
Mm-hmm. Device identifiers or metadata establishing authenticity. Oh, girl. It merely reproduces fragments of text and messages without explaining how or from where they were obtained. Expert testimony based on undisclosed or unverified methods fails the reliability requirement of Sargon Enterprises v. USC 2012 and does not satisfy the authentication mandate of Evidence Code, blah, blah, blah.
All right. We're on F, irrelevance and temporal remoteness. All data Mr. Berryhill reviewed originated from respondent Maricini's device and dates from 2016 through 2018, 7 to 9 years before this hearing. Those communications predate the incidents that led to issuance of the restraining order and have no, they were at the same time. There were messages before and after Iceland.
Yes.
There were, what is she talking about? What?
I don't know.
The hospital pictures.
Yeah.
The smoking gun hospital pictures.
Exactly. Oh, those were so good.
The Uber, I have seizures because of
Yeah.
Uber accident.
Right.
These are all relevant. My head's going to fucking explode.
Oh, yeah.
Was she crazy? Those
Yes.
communications, yes, that led to issuance of the restraining order and have no bearing on petitioner's present apprehension of future abuse. Evidence so remote in time is inadmissible. No, I doubt it. I doubt it.
Improper credibility in character testimony. Mr. Berryhill's stated purpose, confirming that multiple documents were fabricated or altered, is a direct attack on petitioner's
credibility? You mean the credibility that her own lawyer said was terrible? He's like, well, Your Honor, I know that my client has lied in the past, which is, bad for her credibility.
Yeah.
We know, but this, that was my Exhibit A. Remember? Exhibit A, when he said he was going to sue all of us for calling her a liar.
Yeah.
Then he files a motion that says, I know my client has a credibility issue. I circled it in red. I labeled it Exhibit A for any defamation lawsuit that this idiot tries to bring against me. Your Honor, Exhibit A.
Exhibit A.
This man wrote this, that his client has credibility issues.
She does. She does.
Oh my God.
California law forbids experts or lay witnesses from testifying that another witness is dismissed.
All right, I have to go down and get the food. You want to keep reading?
I can keep reading.
All right, you keep reading. I will be back.
Okay. Because credibility is for the court alone, such opinions are inadmissible. Section H. Prejudice and confusion, allowing testimony about an unsupervised partisan forensic report and decade-old text messages would convert a limited renewal hearing into a collateral trial on unrelated issues. What? Are you crazy? The probative value of this evidence is non-existent.
I can't find my shoes.
Uh-oh. Do you want to wear these flip-flops?
Yes.
Oh, here's these, but this will be easier.
Yeah,
Flip-flops. Flip-flops.
All right.
You could probably ski down.
But then my
stairs.
oh, these aren't too bad. No, these are not uncomfortable. I should have bought some.
Better than the other ones. Oh, somebody slipped us something.
A note.
Quiet.
I don't know.
The probative value of this evidence is non-existent. The danger of unfair prejudice and confusion is extreme. Evidence code, blah, blah. The court should exercise its discretion to exclude it entirely. Oh dear. She didn't mute her mic? What do you mean she didn't mute her mic? Well, if she mutes, we're using one mic. That's probably why it sounds weird. I don't know. I'm not going to ignore you guys' chat. I'm just going to distract me, though. Sharing shoes. That's how you get big twins. They're flip-flops. It's fine. It's fine. Section 3, to exclude witness number 5, Gregory Gillespie. See Exhibit C. A. Respondents proposes to call Mr. Gillespie to repeat discredited allegations from Arizona litigation. Discredited allegations? Huh. That were resolved entirely on procedural grounds and never adjudicated as true. Okay. I'm not as up to date on Greg's stuff, so this one's confusing to me. I need somebody to tag in. No court has ever found that petitioner falsified a Laura. No, that petitioner falsified a pregnancy, submitted a forged ultrasound, or misused protection orders. Such testimony would be irrelevant, misleading, and unduly prejudicial. Chat, what the hell did she just say? No court has ever found that petitioner falsified a pregnancy, submitted a forged ultrasound, or misused protection orders. I'm pretty sure we have some indictments happening right now about altered documents and perjury. Well, oh brother, this is, oh, really, Megan's missing out. Oh God. Identification and stated purpose of testimony. Respondent proposes to call Mr. Gillespie to repeat discredited allegations. Wait, did I just read that one? Oh, I did. B, their relevance to renewal order or under family code. A hearing on renewal is not a retrial of the original abuse allegations. The inquiry is limited to whether the protected party entertains a reasonable apprehension of future abuse. Well, I think we've already determined you're unreasonable, so there's that. And allegations concerning a separate Arizona civil case have no bearing on whether petitioner continues to fear respondent Maricini. Under evidence code law, such testimony is irrelevant and inadmissible. Yeah, I think just the fact that Mata referred her to the district attorney, or I guess it was the district prosecutor, is enough there, right? That's not good. 7 felony indictments, yes. Sorry, I'm trying to catch up with you guys. Yikes. Oh, goodness. So sorry, Kathy. Yeah, this is going to be a wreck for sure, Marco. No adjudicated findings of fabrication or fraud. Okay. No, they have not been adjudicated just yet. The Arizona record affirmatively shows the absence of any finding that petitioner falsified a pregnancy, forged documents, or abused the protective order process. In Owens v. Gillespie, 2021, the defendant's own second supplemental Rule 26. Okay. Disclosure statement filed by Greg Woodnick merely alleged that petitioner reportedly fabricated a pregnancy and subsequent abortion, but cited no supporting evidence. Laura. Petition's motion for partial summary judgment established that Gillespie did not suffer a consequent proximate injury. Sorry, I must be getting tired. Injury. Did not suffer? Did not incur damages. Did not suffer severe emotional distress. Well, I don't like it. I don't like it. He did. He absolutely did. Yes, Rule 26. Got to bring it up. It wouldn't be a filing without some Rule 26 references. The minute entry for November 9th, 2023, Honorable Michael D. Gordon granted both parties cross motions for summary judgment, expressly finding that the damage disclosure made by the defendant counterclaimant with respect to the fraud are insufficient for both claims. I really need to go back and look at that because I really have no idea. Those rulings disposed of Gillespie's fraud and emotional distress counterclaims solely for lack of proof, not because petitioner fabricated evidence. No Arizona court has ever entered a finding of perjury, forgery, or false pregnancy. That's not true. That's why she was referred, is because the judge found it, and the judge is the court, right? Am I getting gaslit here? I feel like I'm getting gaslit by this document. Like, you don't remember what you think you remember. Yeah, I wish we had the soundboards here. Say Rule 26 one more time. Maybe not. Regular. 7 counts. Yes, 7. 7. Was it 4 perjury, 4 counts of perjury, 2 tampering with evidence, or falsifying documents?
Oh my gosh.
Are you listening?
Yes.
I'm getting gaslit, aren't I?
You are. There are no findings of perjury. Yeah, no, there are. And that's why you got referred.
Yeah, the judge is the court.
By the way, the note we got under the door, you're going to love this. Hold on, put my camera back on. The note we got under the door says, we would like to inform you that starting 10/21 Tuesday to 10/24 Friday, we will be working on our Wi-Fi upgrade throughout the building. Although we do not anticipate major disruption, there could still be possible internet downtime. Oh, these motherfuckers in the Wi-Fi. Brad! Pounding on the wall. I mean, honest to God. So, of course, I can't even come away halfway across the country without internet problems. It's me, isn't it? How do we choose the one hotel that on the 3 days we're going to be here, they're doing a Wi-Fi upgrade? Oh my God. All right. It's time for us to do super chats, and we have to end this because I have to get ready for the stream with Tug, and we will come back and at some other time, probably tomorrow, and either finish. Well, tomorrow we're going to have updates on what happened in court, so we may not even need to finish going over this. Right. But you guys can read it. You've seen the documents. I'm sure it's up on Victims of Laura Owens, correct?
Sure. One of them anyway, or even all the best.
No, okay, so I did check. It doesn't look like Omar has filed a response. I think he is going to be responding in person. I think that's what's going to happen in court tomorrow. But we will have more updates on that for you tomorrow. But we will definitely be there first thing in the morning.
Absolutely. With bells on. Well, maybe not the bells.
Maybe not bells, but we will have our shoulders covered though for court. You must cover your shoulders for court.
Absolutely.
So yeah, so it won't be a shoulder day. All right, let's see. Where did I leave off with super chats? I was at. Oh, here we go. Megan is too far back to see good shoulder views, though. Well, you get what you get. You don't throw a fit. Cynic in Chief, thanks to the 5. If these medical reports are faked and the California DA uses it for more charges of perjury and evidence tampering, I'm going to cackle harder than Georgie. Yeah, I mean. That's what I see coming. I see more referral to prosecution. I do. Rachel Taylor, thanks for the 5. My husband Adam said, this is for the shoulders. Thank you.
Who knew shoulders for such a thing?
Jules, OMN, thanks for the 2. LO, issue is she knows she's caught and trying to hide. Yeah, definitely. SF, thanks for the 5. My mom had vomited blood and was immediately put in the ICU. Turns out she had liver disease. Oh my God. Yeah, I mean, this sounds like you have to be admitted immediately.
Right.
You can't be vomiting blood and then
Needing a transfusion?
Yeah, come on.
How do you know you need a transfusion
Come
if
on.
you haven't seen the specialist yet?
Allie S, thanks to the 5. The shoulders are out. Tori will be having a meltdown. Yes. Chris Jenner, thanks for the 2. Has anyone run this filing through an AI detector? We haven't done it yet, but that would be fun to do.
Yeah.
Rickle64, thanks for the 5. Have an ice cube on me. Well, thank you very much. I appreciate that. Liz Shark, thanks for the 5. What's the plan tomorrow? I'm coming. That was for an ice cube at the House of Prime Rib, by the way.
An ice cube.
It's $4.99 for an ice cube.
I'll take it.
What's the plan tomorrow? I'm coming to the trial. Are we meeting in front of the courthouse? What time does trial start? Can't wait. Liz, I don't think we're meeting in front of the courthouse. We're just going to go into the courtroom and sit and be quiet. That's my plan.
Are you good at sketching? You could be
Yeah,
a sketch
if you're a
artist.
good sketch artist, we could use one. We have a contest going for who can do the best sketch artist drawing from inside court tomorrow, since no cameras will be allowed. But we'll see you there, Liz. Mary Lankins, thanks for the 2. See you tomorrow. Chester is letting me free. Oh man, Mary Lankins is coming. This is amazing. I want to meet Mary in person.
Absolutely.
Darcy, thanks to the 10. Hard Knocks is good food, FYI. I'll remember that. We'll have to remember that. Rickles, thanks for the 2. Shoulders. Rickles. LOL. Salty Veruca, thanks for the 5. How did she have time to write all this? In between medical emergencies with no assistance from a lawyer? Totally believable. I love Salty Veruca and your icon, your avatar there. That's great. AKA the Cat Lady, member for 14 months. This isn't a civil trial. This is an evidentiary hearing. Just when I think she can't go lower, she proves me wrong.
New blog. Didn't she?
Jingy has a new blog.
Mm-hmm.
Shut up. What's it called?
I don't know. Check out Baby Gingy's new blog tonight.
Oh, no.
Brittany says.
Mel Klump, thanks for the 2. Megan and Rosalind are awesome. Rosalind is awesome. She is. Maybe not. Gifted 10 Megan Fox memberships. Thank you so much for those 10, and welcome to the Fox Den, all 10 of you who got that. And that's a great note to end on. Let me check Cash App to see if anybody sent us anything on Cash App, because that's for House of Prime Rib. So we want to see how that's going. Let's see. Do we have any Cash Apps? How do I get to the thing? There we go. For whatever reason, no, we're good on that. But I did not get to say thank you to Laura yesterday. Laura sent me $25 for steak yesterday on Cash App. So thank you very much. We're trying to get to that prime rib. We have no idea how much it will actually cost. It looks extremely expensive. So I think for now, we'll just have drinks and an appetizer and we'll be fine. All right, it's time for us to eat. We will be back when we can, you guys. So just keep an eye on this channel. Make sure that you have your notifications turned on. If you're following me on Locals, I do try to put announcements up there, meganfox.locals.com. You can follow for free. So definitely just pay attention to my Twitter as well, at Megan Fox Writer, because I always put up notifications there as well. All right, guys, thanks for showing up, all 928 of you, and we'll see you soon, right? We'll see you soon. All right. Where's my video? What shall we play on the way out? I bet we have a song we can play.
I don't know. What do you want to play?
Do I have one? I think I had to take them all out.
I think we went through this yesterday.
We went through this yesterday, didn't we?
Mm-hmm.
I thought I had Pond Scum Posse in here, but I
did have Pond Scum Posse.
It appears to be gone today.
It was down at the bottom, I think.
Yeah, and it's gone.
That's weird.
Totally weird. I wonder if I accidentally deleted it while I was trying to decide what to play.
Are you on a different format?
No, it's just not there. All right. Well, we'll just go with this. Bye-bye, everybody.
It's Douche Canoe and Pregnancy Faker.
Yeah.